Thanks.
SJC-13230, Thomas F. Williams, via Board of Appeals of Norwell.
Okay. Anyone?
Good morning, Your Honor. It's a pleasure to be before the court. If it pleases the court, I represent Attorney Thomas F. Williams in a silk. I apologize, Your Honor. Hold on one second. Zoom. So I represent Mr. Williams. Mr. Williams applied for a
We
building
can't hear you
permit.
now.
I'm sorry. Can you hear me, Your Honor?
Can other people hear?
Yeah.
Okay. Mr. Williams applied for a building permit back in 2009. And that building permit was granted by the town of Norwell building inspector after he drove down Stony Brook Lane to inspect the site. That building permit was appealed by the LaRues, who are neighbors who utilize Stony Brook Lane as their right-of-way to get to Main Street. And upon that appeal to the ZBA, the building permit was appealed further to the land court. And the land court's decision was then appealed in 2014, which established a couple of factors. One of the factors established was that the existing right-of-way, known as Stony Brook Lane, does exist on the ground and does provide access for Mr. Williams. And it also established that the 1942 zoning bylaw was an applicable bylaw in place to analyze Chapter 40A, Sections 6's grandfather provision.
So you're saying, counsel, you're saying that the 1942 bylaw is the one that is appropriate?
Yes, it is.
Okay, so tell me, and then you also mentioned the right of way. Can you tell me what more needs to be done? Does that, if you are not successful, can you go back to the planning board or the whoever it is and get that road declared a public way for your purposes that might change things?
It wouldn't be considered a public way for the planning board. If the court is going to decide that this matter needs to be, the only thing is it's a pre-subdivision control law plan that was recorded by Mr. Williams' lot. It was created in 1948,
right?
And that was prior to subdivision control law. So the planning board doesn't really have much jurisdiction over this matter. Except for establishing A&R plan if it does go before the planning board again.
Well, that's I guess what I'm asking is if you are not successful, is there a route for your client to go back and become successful?
It would be more of I guess the answer to that question is that the planning board will have to establish the same factors as it is now. That is before the court. That it does not require the planning board's approval because it predates subdivision control law.
Okay.
And the only thing that can be applied is a A&R approval to the Stony Brook Lane. And that's in essence where we're at. When the court is asking me if there's another avenue, I don't believe that there's necessarily any need for that avenue.
Well, I understand you don't. I was just trying to understand the consequences of the appeals court decision, and just trying to understand the consequences of where you are right now if you're not successful this. But we can move on. Can you also tell me, do you agree or disagree with whether the judge was judge right in concluding that the 1950 bylaw was would have implications on this in some way?
It wouldn't, because the 1942 zoning bylaw was what was determined to be the applicable zoning bylaw.
I know, but then we bump into Lincoln, right? We bump into the land court's case in Lincoln. So how do you resolve that?
Well, the Lincoln case established, it purported to invalidate the 1942 zoning bylaw based on procedural non-compliance. And the court's SJC, your decision has established that procedural noncompliance, minimal ones, are not considered. It has to be looked at very carefully before a court can invalidate that.
All right.
And so based on that court decision, this court has the power to determine that the ruling by the land court back in 1947 was incorrect, in order to provide the town of Norwell with some guidance as to its bylaw back in the 1940s. So what I'm trying to indicate is that that court decision permits the case doctrine to apply, or the court can apply, or the court can determine that the land court decision back in 1947 was invalid, in order to provide the town of Norwell with further guidance as to other property uses that occurred back in the 1940s.
Before you explain that in more detail, if I could just go back, and the reason for the question is very similar to Justice Cipher's initial question about whether there needs to be a remand here or not, or at least whether there's an avenue for it. So if the law of the case doesn't apply, and if the 1942 bylaw was invalid, and if there was no zoning bylaw in 1948, it seems that there wasn't, and if the 1955 bylaw does apply, and this is not a subdivision, is there a vehicle, is there an argument that you would still win?
Under the exemptions of Chapter 41's section FF, it's property that are not held in common ownership are exempt from certain regulations, and the legislatures in both Chapter 40A and Chapter 41 provided that exemption for bona fide purchasers of lots that were not held in common ownership for any changes in zoning and any regulations that a planning board would apply. So that avenue was still, what I'm trying to answer the question is that I'm trying to get at the point is that it's the lot, the Stony Brook Lane is a right of way that serves the locus. And that determination was based on plans and deeds that was recorded in 1948. And that triggers both Chapter 40A and Chapter 41. It's exemptions to lots that were prior created.
So I'll be frank, I'm not sure I understand. Explain to me, if you could, how you can use Stony Brook Lane to get to the required frontage.
By looking at the 1942 definition as to frontage, that required 100 feet of frontage in 1942.
You're talking about the 1942 bylaw?
1942 bylaw.
Yeah, but the predicate of my question was that if the 1942 bylaw was invalid.
If the 1942 was invalid, then Chapter 48 would apply. The Section 6 of the 4th paragraph would apply, that it only requires 50 feet of frontage upon a way and the minimum lot size requirement. It's the application of a circumstance where for the enabling act for the zoning changes occur, it permits lots that were not held in common ownership to be protected from any further changes. And so that is the avenue for which that Mr. Williams' lot would be able to be utilized as to build a single family residence. I guess the question that is my understanding of that grandfather provision, that it sets minimum lot size requirement, it sets minimum frontage requirement, and Mr. Williams' lot meets those requirements when there's a circumstance that there's no bylaw in effect. There was a bylaw in effect, but if we're trying to indicate that it was not in effect, that chapter permits the protection that allows Mr. Williams to build on his property. I'm hoping,
Well, you understand that, you understand they're gonna say that's not right. It's the 1955 bylaw when there's no bylaw.
the 1955 bylaw indicates that a right-of-way has to have some sort of approval from the planning board. If the court's considering that substantively changes the frontage requirement, and chapter 48 would apply. If the sections, the first sentence of the section 6 would apply. I guess my reading of it seems to be in that regard, is that if there is any zoning changes that prevents a single lot from being built on a property that's not held in common ownership, if any zoning bylaw causes the changes, the grandfather provision would apply and protect the lot from being rendered unbuildable.
But only if you have 50 feet of frontage, isn't that right?
Yes, Your Honor.
So I thought the question for us was, how do you define frontage? And what resources do you use to arrive at that definition?
You define frontage in a certain sense where if there's 1942 laws not in place, because this is for the premise of the case that went before the appeals court, that the 1942 bylaw required 100 feet of frontage, and that was what was applied. And then further bylaws, if the court considered it to be substantive changes to the 1942 requirement, then chapter 48 would apply to protect the lot from any increase in frontage requirement.
Subject to a minimum of 50 feet.
Subject to a minimum of 50 feet. And in the 2014 factual findings, has already established that the lot has more than 100 feet of frontage.
Where is that in the 2014 opinion?
The 2014 can indicate that that Stony Brook Lane crosses a locus for more than 100 feet. That would be on the second.
And so how does that square with having more than 50 feet of frontage? Are you equating the two? Crossing over the locus for more than 100 feet is the same as having at least 50 feet of frontage?
Yes, Your Honor. That is.
What is the reasoning behind that? I'm not challenging your conclusion. I'm trying to understand why right-of-way crossing through a locus for more than 100 feet is the same as having a minimum 50 feet of frontage.
And there's why this case has been broken down to two different sections. The first 2014 decision went through the analysis of the 1942 zoning bylaw, which requires that a single family lot have.
So assume that we disagree with you and that law of the case is not going to apply for the particular reasons at issue here. Why does having a locus, a right of way that passes through a locus for more than 100 feet satisfy the paragraph 4 requirement of having a minimum of 50 feet of frontage?
Because I'm trying.
I think that isn't that the core of the appeal. Yeah.
It is the core of the appeal, but it is if it's 100 feet that crosses over the locus, and that is defined as the frontage for the property.
But yeah, so stop there and tell me why what you just said is correct.
If you look at the bylaws, even the 2009 bylaw, it states frontage as a continuous and uninterrupted portion of a sideline of a way. That's the 2009 definition of frontage. So the appeals court determined that the 100 feet of frontage in the 1942 bylaw, it met that requirement. And the appeals court indicated that all the evidence points to the fact is Stony Brook Lane crosses the locus for well over 100 feet. So it meets the it meets a 2009 definition of frontage, a continuous and uninterrupted portion of a sideline of a way. The only question is that we're trying to argue what a way is, why a way is what a way means today. And a way means today apparently requires a planning board's approval that it is a way.
So does, assuming I understand that last answer of how that gets you to 50 feet of frontage, the fact that Stony Brook Lane is a private way and hasn't received approval from the planning board, how does that impact your last answer?
Approval by planning board, the town has adopted it through its subdivision control laws, a map that depicts Stony Brook Lane as part of the town's accepted ways. It's on A&R plans that the planning board has already endorsed and filed the registry for numerous properties to utilize Stony Brook Lane. So the planning board has accepted Stony Brook Lane as a right of way. It doesn't have to be a public way. The town of Norwell permits private ways and also public ways. So I guess I'm trying to understand how a private way to service 7 other residences is not considered a right of way for Mr. Williams' lot, when the facts has already been established in 2014 that Stony Brook Lane crosses over the locus, and there's no other evidence that indicates otherwise, that the right of way in 1948 is Stony Brook Lane. So that factual findings permits the court to determine that Stony Brook Lane serves as frontage for the property under the bylaws that is established.
Just one final question for me, and that is, would that be true regardless of what, that wouldn't be true regardless of what bylaw is applied, though? You're dependent on that 1942 bylaw.
If the whole premise of this case is a requirement that the planning board somehow has to determine this private way is considered a way. The planning board lacks authority with regards to lots that were predate the subdivision control law. The only authority that the planning board has in this circumstance is to adopt an A&R plan and have that filed, because the lot was created prior to subdivision control law and had an existing right of way.
So you're saying then if the 1942 bylaw doesn't apply, that's the route that you go?
Yes, Your Honor.
Okay, thank you. That I got it now. I understand. Okay.
Okay, thank you very much. Attorney DeLisi?
Good morning, Your Honors. May it please the court. My name is Attorney Jeff DeLisi, and I represent the appellees, Gregory and Mara LaRoe. In my supplemental memo to the court, I argued that the land court judge was correct in her ruling because the 1942 zoning bylaw had been invalidated prior to the recording of the 1948 plan that created the lot, and thus that the courts are to look to the meaning of frontage in the town's zoning bylaw. However, in preparation for this argument and going back to the language again and again of the statute, and reading and rereading the cases of Rourke v. Rothman and Adamovitz versus Ipswich, I came to the realization that it actually doesn't matter whether or not the 1942 bylaw was annulled in 1947. And because what matters, according to the cases, is the status of the lot at the time of the most recent instrument of record prior to the zoning change that rendered the lot non-conforming. In 2009, the decision of the Norwell Zoning Board of Appeals, which overturned the issuance of the building permit, did not engage that analysis if you look at the decision. And in 2013, the appeals court, in remanding the case, also did not engage that analysis. On remand, the town's decision on remand also, if you read it, does not indicate when the lot was first made to be non-conforming and does not seek to identify the most recent instrument of record prior to the zoning change. So in order for me to address that issue for the court today, it is necessary for me to briefly review the legal framework set forth in the statute. The first sentence of the fourth paragraph of Mass General Law, Chapter 48, Section 6, exempts certain lots from increased zoning restrictions, provided that certain minimal conditions are met. Those conditions are, at the time of recording or endorsement, whichever first occurs, the lot had at least 5,000 square feet in area and 50 feet of frontage, was not held in common ownership with any adjoining land, and conformed to the then existing zoning requirements. It is well settled law in Adamovitz and Rourke v. Rothman that the phrase "at the time of recording or endorsement" means the time of the most recent instrument of record prior to the effective date of the zoning change. Now, in the second summary judgment decision, which is on appeal before this court today, the land court contained two rulings that are essential to that analysis. The first was that the zoning bylaw adopted by the town of Norwell in 1959 was the first bylaw that rendered the property non-conforming, because it required that lots of 2 acres or more have at least 40 feet of frontage, which was defined in that bylaw as frontage being on a public way or a way approved by the planning board. The second essential ruling that the land court made in that decision was that the most recent instrument of record prior to that 1959 zoning change was September 24th of 1957. That deed, for the court's reference, can be found in the Record Appendix, Volume 4, page 28. Since frontage is not defined in the act, we're to look to the meaning of frontage used by the municipality. And the land court focused on looking at that meaning in 3 critical junctures. And it came to the conclusion that the result's the same no matter which juncture you look at. That being the present date, that being the language used in the 1959 bylaw that rendered it non-conforming, and that being the language in the bylaw prior to 1959, which was adopted in 1955 prior to the most recent instrument of record. So what does it all mean? What it all means is that the lot, at the subject lot in this case, was not once buildable as that term is used in the statute. Well, not the statute, but it was not once buildable, did not comply with the then existing requirements, because as of 1957, it did not have frontage on a public road or on a way approved by the planning board. And so I believe that the land court analysis on that question was actually spot on. And when I wrote my memo I was so focused and laser focused on the issue of, is the 1942 bylaw invalidated and what does that mean, that I forgot to look at the most recent instrument of record prior to the date of the 1959 zoning change. Once you look at that, it means that the 1942 bylaw, whether it was valid or not valid, is irrelevant to the analysis. And I think that that is my entire argument today.
Well, is it relevant to the understanding of what frontage was in 1948 when this lot was created?
It's doesn't
Because I think
matter.
that the whole point of this paragraph 4 is to render buildable things that were buildable before the change. And
Right,
if
but-
you allow a subsequent redefinition of frontage, and then apply that as the 50-foot of frontage required, it seems like a big loophole towards the legislative purpose of allowing buildable lots to remain buildable.
But the statute requires that
Which-
that
yeah.
the Mass General Law, Chapter 48, Section 6, fourth paragraph, first sentence, requires that the analysis on that begins at the most recent instrument of record.
And the
At the-
most recent instrument of record, what was filed? What document is that? You're telling us to look at that. And what is
Yeah.
it?
So that is a deed
A deed.
in 1957. That is the most recent instrument of record prior to the adoption of the 1959 bylaw that rendered the lot non-conforming. And that deed is located at the Record Appendix, Volume 4, page 28.
Thanks. Could you address, and my colleagues can go back to this if they want to, but for me, can you address the law of the case argument that's been made?
Yeah, in speaking with Robert Galvin, who's town council, he said to me, I make no apologies in getting it right. In this particular case, Mr. Galvin was not participatory in that initial trial, and town council didn't stipulate. The decision of the Zoning Board of Appeals in 2010 didn't seek to construe the words 1942 bylaw weren't even used. And it only came to be by virtue of a stipulation at the time of trial between the two private defendants. And there never was a determination at the land court on that issue. When the matter got to the Court of Appeals, the case was, the land court case was, or the land court judgment was overturned on the basis, as stated by the court, that the land court was incorrect in its ruling that the land court's ruling was based on incorrect subsidiary findings, was actually the language used. And that the court said, even though the 1942 bylaw doesn't use the word frontage or doesn't define frontage, lot width is essentially tantamount to frontage. And you could have a proper lot width on a passage. And that's how it got there. So on the issue of the Court of Appeals initial remand, the whole concept was that it was based on incorrect subsidiary findings, that the land court decision was based on incorrect subsidiary findings. But the Court of Appeals didn't even actually determine, appeals court, Mara had told me, say appeals court, not Court of Appeals. The appeals court had not actually determined that the 1942 bylaws were were the operative bylaw. It just picked up on the stipulation initially. And so when you look at the case law concerning this issue, you're going to see that there are various justifications for the circumstance that we're talking about, which is the law of case and essentially going in a different direction. And that is, if the matter had not become final, and in this case, it went from the land court to the appeals court to the land court to the ZBA, back to the land court, up to the appeals court, and now here, it never became final. And in addition, the appeals court decision remanded it to the land court to remand back to the town for purposes consistent with this decision, is what the language says in the appeals court decision. And that's exactly what the land court did. And it was only once it got to the ZBA and somebody said, hey, I think I recall that the 1942 bylaw was annulled. That was the first time the ZBA even dealt with the 1942 bylaw in this case. And they got it right. So there are good reasons to overrule the law of case doctrine. If manifest injustice would occur, if there are new facts that come to light, if the decision had not become final, all of those are apparent in this case, in my estimation.
Counsel, since it was a stipulation, can you count it as a decision of the appeals court?
Since it was a stipulation, can you count that as a decision of the appeals court?
Is there a difference between accepting a stipulation and a court making a decision or making findings?
Well, of course, I think that there is, right? Because
Right.
the court did not rule on that. If the court ruled on that and actually looked and said, okay, here we have a case, the most recent instrument of record is 1948, which that's not the case. And at the time, the frontage requirement was 1942 bylaw. There was no ruling on that. And so I do think that there's a difference between stipulation in one instance and a ruling on the other.
Can I
Isn't it
follow
also-
up on that? Sorry.
Yeah.
No, go ahead, Justice Wyman.
So you say there was no ruling, but I thought the stipulation was based on the land court's ruling to the effect that the 1942 bylaw was controlling.
No, I don't.
So
think
the
that-
appeals court didn't rule on it one way or the other, but the land court did in the first instance.
I think, Your Honor, the distinction there might be that the appeals court was construing the language of the land court, which was looking at the 1942 bylaw. But I don't think that the land court and the one of the two summary judgment decisions actually said it.
Well, here, let me just quote what the appeals court said in 2014, and you tell me why I'm wrong. It says, the judge found and the parties agree that the 1942 zoning bylaw was in effect in 1948. So it's not just the parties agree, it's the judge found.
Yeah, but the judge found based on the stipulation, and if you read the decision of the land court, the decision of the land court uses the word stipulation.
Okay,
So,
thank you.
so that's
I got
but
that.
it's irrelevant anyway for the
Yeah,
reasons.
there's also case law, stipulating to erroneous legal rulings. I don't know if that, that has any binding effect. I mean, there's some appeals court case law about that kind of stipulation not being valid, but it's not cited by either party. But I have a pretty good recollection that we've written on that, that the appeals court wrote on that subject. I think I wrote it.
Can I ask you another, oh, sorry, go ahead.
No, go ahead.
You said the 1959 zoning bylaw defines frontage as a public way or a way approved by the planning board. Where is that in the record somewhere? That
Yes.
definition? All
Yeah,
right,
so if
yeah, go ahead.
it is, I could find it if you'd like, if you'd
Well, I
like.
know the zoning bylaws, volume 3, page 16, if that helps you locate the definition of frontage.
So if I could find it, it's like that show, Name That Tune. I can find it in 30 seconds here.
Oh, that's
Um,
okay. We don't need to take up time doing that. I just.
So the 59 zoning bylaws in various locations in the pleadings, but it's page 45 of my most recent supplemental document. And when you look at that page 45, what you're going to see is addendum E, and then it's actually on page 47. Of course, I put the whole bylaw in. So it's in there. And what it says is that it literally is in the exact paragraph that I quoted, Your Honor. And it actually says the word frontage is used in this section shall mean frontage on a public street or on a way approved by the planning board. And then it goes on to say that properties of 2 acres or more shall have frontage for a distance of 40 feet, which is less than the zoning statute of 50 feet.
Right, and I
Irrelevant.
guess that was my question, is like, given that this change rendered it non-conforming, and the point of paragraph 4 is to preserve buildability, when one thing was buildable already, does that make sense to use this definition of frontage?
It does, number one, because the statute requires it, and then the case law requires it. But if you look at it, the language of the statute actually requires that you engage in analysis as to whether it was once buildable by going back to the zoning bylaw in effect at the time and looking to see, did it meet the then existing requirements? And so the then existing requirements, before they even imposed the frontage requirement for the first time on the lot, had already defined the word frontage. And the Zoning Act doesn't define frontage, which is a bit of a confusing issue. But clearly, with all your case law, you look at the municipality definition, of course you're going to do that. And it would be in the interest of the act to do that under the purposes of the act, which is to ensure safety, right? How can you have a lot here that has frontage on a right of way that goes through it for the benefit of another lot, and the plan doesn't show the minimum width, doesn't show the bounds of it, doesn't speak of the grade or the slope or the materials? Of course, the Zoning Act or the zoning bylaw in the town of Norwell is going to require that the planning board weigh in on whether the town can get safe access to the lot for purposes of safety. The whole concept, and that's why the 81FF argument doesn't even work, because by allowing the 81FF exemption, even if that is correct in this case, it allows a property owner to subvert the language of the bylaw, which is there to ensure safety. And that's why I think, if we're going to make an argument as to why frontage isn't defined in the act, it's because the legislature has left that up to the town to determine. And at the time, frontage as determined by the town was to be on a street or a way approved by the planning board, which is the other, I mean, to me, that's the answer.